Hi, everyone. So today we are going to be talking about a few things that I've noticed about US immigration and answering your questions live. So if you have any questions, please go ahead and put them in the comments. If you're watching this on the replay, hi, welcome. Ask me your questions in the comments as well. Please say hi, let me know where you're joining me from, and let's talk all things immigration. So first thing, I think a lot of you have known this, but if you have only an I-130 pending or approved, you do not have a status, right? If your I-130 is approved, that is great. It's the first step to eventually get a green card, eventually getting, a visa to the U.S. However, it does not give you status on its own, especially if you are not an immediate relative of a U.S. citizen, because we all know that the visa is always available for immediate relatives of U.S. citizens, immediate relatives of U.S. citizens that entered with either green cards and parole can adjust their status in the U.S. But if you are not an immediate relative of a U.S. citizen and you have an approved I-130, you still have to wait for a visa to be available. And the only way you can adjust your status in the US is if you are in valid status. Again, that's only if you're not an immediate relative of a US citizen. Just in case you don't know what that means, immediate relatives of US citizens are spouses of US citizens, parents of US citizens, and children under 21 that are unmarried of US citizens, including stepchildren and adopted children. Okay. All right. So remember, if you have questions, put them in the comments. And also, what I have noticed too, Farhang, thank you for asking that question, is that if you have questions that you just want to see what other people are seeing with their cases, put them in the comments too. Someone may have answers for you. Someone may be able to relate to what you're asking and to give you some insights as well. So the comments are not just for questions, are not just about questions for me. It can also be questions for just the community over here on YouTube or Facebook, okay? All right, so that is the first thing I wanted to cover, which is approved I-130 does not mean you have legal status in the US. You will need to go through either adjustment of status or consular processing to eventually get a green card, and that is when you will have legal status in the US. If you have an I-130 pending, but no adjustment of status pending, again, you do not have a path to immediately gain status. So sometimes, during administration, we have been people, if you have a case pending, make sure you have your receipt notice on you. Now, if you only have an I-130 pending, you do not have an I-485 pending, that receipt notice is not really going to be as helpful to you. But if you have an adjustment of status, that I-485 also pending, you are in a better position because an ICE agent may be able to see that and say, oh, this person has a case pending that can lead to a green card. But just an I-130 doesn't tell them that, okay? So just keep that in mind. I like mentioning this. I want to reiterate it because I've had so many people tell me or ask me, oh, if I have my case pending, does that mean I'm now in status? Or I filed for my parents, does that mean that they now have status? Unfortunately, until that green card is approved, the person is still not in status according to US laws, right? If they're going to be picked up by ICE or any of those things, is going to depend on a lot of different factors, especially if they have a criminal history, if they're subject to expedited removal, all of those things. So just important to know that. Cases where, second thing I want to cover, cases where you are filing only an I-130. Maybe you're in the US, your spouse is filing an I-130 for you, but you do not immediately qualify for adjustment of status because maybe you entered without inspection and you have to apply for a 601A waiver to then leave the US and come back with your visa. Well, in those situations, USCIS are now more likely to schedule you for an interview. So before, typically a marriage-based case that's just only an I-130 petition does not get an interview. But now we are seeing that those cases can get interviews. So you also need to be prepared for that just in case you are scheduled for an interview. And with the NTA memo that went out, if the person, if you are, having an I-130 filed for you and you do not qualify for adjustment of status because you do not have legal entry, or you overstayed your visa, you entered without inspection, you entered with parole, but the parole has expired, USCIS can choose to issue a notice to appear for immigration court. Again, even though you have this US citizen spouse or US citizen parent or US citizen child filing for you, you may still end up in deportation proceedings because looking at their file, they can see, yes, you qualify for an I-130 because of the relationship, but there's no way for you to gain that status, or that you are already out of status, or you don't have any legal status in the US. So therefore, you can be in deportation proceedings. So it's really important that before you file anything now, I am warning my clients, right? Before we file any application, I am warning them, especially if we're only filing I-130s. Okay, are they issuing removal orders at NTAs? So the notice to appear is for you to go to immigration court proceedings. It does not automatically lead to a removal order unless the person misses their court hearing and the judge orders them to be deported. But typically, if they're issuing you a notice to appear, you have to go through immigration court proceedings. And then depending on if you have a defense, that's really the key with immigration court, is if you have a defense to being removed, then you can use that defense. So for example, if you have an I-130 pending and it gets approved, you can apply for a green card in immigration court if you had legal entry into the US, right? So instead of applying for your I-485 with USCIS, you would apply for it in immigration court. So being issued a notice to appear, an NTA, does not automatically lead to a removal order unless you miss your court hearing. So that's one thing I want to tell anyone listening to this. If you get a notice to appear, do not get so scared that you don't do anything with it, because if you don't show up, you're automatically going to get a removal order. And that is going to be a worst case scenario showing up to court, especially if you have a defense. So make sure that you are, if you get that notice to appear, I'm going to talk about situations that I'm seeing that they're just issuing notice to appear for. But just know, if you get that notice to appear, talk to an immigration defense attorney, okay? Immigration defense attorney. I always tell you guys, I no longer do immigration defense unless you are a current client and I decide to make an exception. But you need an immigration defense attorney if you get that notice to appear, because you need to make sure that you know you qualify for and that you are putting up a good defense so that you don't get a deportation order. All right. So now let's talk about what I have been seeing lately that has just been messing with my brain. One thing that I will say is, when it comes to notice to appears, we are seeing the service centers, not the local field office. So the local field office handle interviews and things like that. The service centers handles cases that typically don't have an interview. So for example, if you're doing change of status to, let's say, a B1, B2 to an F1, if you're doing a extension of status, so you came in with a B1, you came in with a B1, B2, and you want to stay longer, so you file an extension of status, but right, you file extension of status, but then it gets denied. USCIS, the service center that handles those applications, are now allowed to issue notice to appear. So remember, if you overstay a visa, even if you file an extension, you are overstaying if you remain in the US waiting for that extension. If the extension gets denied, it goes back to the date you should have left, right? You have overstayed for all that time. So let's say your date is supposed to end like 6 months ago. You filed an extension of status on time, but it took them 7 months or 8 months to make a decision. That means you have overstayed by at least 8 months, right? You have overstayed your visa. Now, because they can see in their records, you filed for this extension, we denied the extension, we can issue you a notice to appear because we don't see that you have status in the US anymore. So that is what we're seeing. I have seen this for an extension for an H-1B. I have seen this for an extension for an F1, not an extension, but a change of status to F1. I have seen this for TPS renewals. So just know that it is happening. So when you're filing that change of status, when you're filing that application, including I-130s, remember, most I-130s that do not have a green card application attached to it are typically dealt with at the service centers, not the local field offices, unless there's a reason to have an interview. Okay, unless there's a reason to have an interview. So in those situations, if that I-130 is denied, or if they feel that they can issue a notice to appear, I'm seeing now that they are going ahead and issuing those notices to appear to individuals and basically forcing you to go through removal proceedings. Now, another thing I'm noticing with these notices to appears is that they are not only issuing them quickly, they are also having your first hearing very quickly after issuing you to the notice to appear. So typically, if you have a case denied by USCIS, you have 30 days to either appeal if it's a case that can be appealed, or you have 30 days to do a motion to reopen, a motion to reconsider. What I have been seeing is they will wait that 30 days, that 33 days, if it was mailed to you, to see if you file a motion or see if you appeal the decision. And if they do not see an appeal and they do not see a motion, they feel now we're in the clear and go out and file that notice to appear. So it's really important that you pay attention to your status, and you make sure, please make sure that you are updating your address every single time you move so that you do not miss any notices. Because if you miss a notice, you can end up not knowing that your case was denied and then end up not being able to respond in time. Okay, so make sure you are updating your address because they are just handing out NTA for denied cases. All right, Guyanese Esquire, are you offering mentoring for people who want to into immigration law? Yeah, feel free to reach out. I will say this, like, I think I mentioned this before. My focus is not removal proceedings. So if you're looking for mentoring for removal proceedings, I am not the person for you. I can probably refer you. So feel free to reach out, DM me. And we can talk about that and see what you're looking for as far as mentoring. But if you're looking more at family-based waivers, naturalization, that's my thing. All right, next question. Yeah, Leona, feel free to reach out. once you are ready to get that citizenship, it is, they're trying to make it harder to get citizenship these days. However, it is not as hard as people are making it out to be. So feel free to reach out. And yes, absolutely, for the culture, always. All right. Okay, Sam is asking for a friend. She had an asylum terminated 10 years ago without prejudice. She has now overstayed her F1. To my knowledge, she has no criminal charges. What are the dangers she could face? So once you overstay your visa, there's a weird thing with F1s, right? There's a weird thing with F1s where F1s get something called duration of status and not just like a term limit of when they are supposed to be in the US. Okay. Not just when they're supposed to be in the US. There's no term limit basically for when an F1 is supposed to end. So typically, unless CIS actively terminates their F1 status, then they will put them in deportation proceedings. Without criminal records, there are dangers that if USCIS sees that they are no longer attending school, because guess what? The school has to let US immigration know that the student is no longer attending classes, and they may cancel their civis record. And if they do that and they do not have any other status, then they will end up basically in danger of being given a notice to appear. Depending on how long she has overstayed her F1, she may want to consider reapplying for the asylum if she still qualifies for asylum. So typically, if you are in legal status, um, you can make an argument that you're still within the time frame to apply for asylum because of the 1 year deadline, right? There's a whole 1 year deadline from when you enter the US. You're supposed to apply for asylum, but if the change in circumstance, which falling out of status with the F1 can be seen as a change in circumstance, she may be able to file the asylum since it was terminated without prejudice. Which that terminated without prejudice basically means we're not approved, we're ending this right now, but if you want to apply again in the future, you can. So she may want to consider that in the future. Okay. And yes, feel free to ask me questions. Okay. Have you seen a faster turnaround for certain types of cases since the new administration began? Um, it's it depends on the field office. So I have seen, I am in New England, so I typically deal with the field offices in New England. For example, Lawrence, Boston, um, Providence, all of them. I can't think right now. But one thing I have noticed is when we are filing all the adjustment of status applications we filed kind of at the end of last year, beginning of this year, have basically gotten interviews already. And we are not even, typically it takes a year to get an interview, but we are seeing that we are getting interviews quicker for adjustment of status applications, especially those based on marriage, because they want to get through those and see if the marriage is real, and if they have any issues with that, they are issuing a notice to appear once they deny the application. So that's what we are seeing, is that those adjustment of status applications are moving faster than usual. And also work permits. So marriage-based green card work permits, I have noticed as well. We filed one in June. In July. And by end of August, we already had the work permit, two of them. Within a month of filing, we had the work permit. So we are also seeing those sped up. Again, it may just be that month, right? It may just be that month. because we also have ones that have been pending for longer that still have not been approved. So it just depends on where the file ends up, the service center it ends up in, the field office it ends up in. That's what we're noticing, is that depending on the type of case, the field office or service center is at, you may get a faster turnaround on your adjustment of status and your work permit while you're waiting for that adjustment of status to kick in. Okay. Oh, and then with that, I want to mention that if you are, if I had to start, if I had to go through my own immigration journey in 2025, one thing that I will do is open a My USCIS online account. When you file your application, they sent you a code and you can use that code to track your case on the USCIS website. Not checking your case status. That's not what I'm talking about. I'm talking about creating an account with USCIS with that code so that you can see if they issue a notice on your case, you can actually download it right from the website. If you need to upload documents for the case, you can do it on the website. Like, it is so much easier in 2025 to deal with, especially with the technology that we have now. So that's one thing that I'm encouraging my clients to do, is you can sign up for that account so that you can keep track of what's going on. One downside, there's only one downside to the account that I always let people know, is they will give you like a time of when they're supposed to process your case by. This is when you should expect a decision. When I tell you that that is not accurate, I really mean that is not accurate. So I've had clients that theirs went from like, oh, you should have a decision in a month, to then it jumped to like a year, and then it went back to 3 months, and then 6 months, and it just keeps fluctuating. And it is not helpful, especially for my clients that are so nervous about the whole process. They're so ready for everything to just move through quickly that you're looking at this timeline and it's just not what you're expecting. So when it comes to the online account, use it for what I'm talking about. Use it for checking if there's a decision on your case, if there's a new document uploaded on your case. Use it for that. Do not use it for their little timeline thing, because it is always inaccurate. I have not had one client tell me that it's been accurate. So don't use it for checking how long things are going to take, but use it to check if you have a update on the case, if there's a case status, if they uploaded like biometrics notice, if they uploaded a decision, things like that. You can see it right on there. I have an attorney account, and for all my cases that they choose to put on the attorney account, I can see it. So unfortunately, I'm not able to like add cases to my attorney account. If USCIS like forgets to add it, it just doesn't get added. But the cases that we are able to add, or that USCIS has added to my attorney account, it has made things so much easier, especially with deadlines. So if you have a request for evidence and you know that it is due, like let's say today is due today, but you got all your documents, like you just barely got all your documents the day before, you can just upload it, except for medical records. Except for the medical report, that's the only thing you can't upload. You have to mail that in. But when it comes to like, oh, we need more evidence of your relationship, you can scan that and upload it. And you can respond that able to respond like the day before the thing is due, because we have that attorney account and we're able to upload things for our cases and for our clients. So really important. That's one thing. That is one thing that I would do if I was going through immigration right now, is make sure I have that My USCIS online account, because it is helpful. It is very helpful. And then Okay, I don't see any other questions. Feel free to ask me questions. And as always, if you want to schedule time with me, ask me confidential questions or just get an idea of what your case is looking like or what you can do, what you qualify for, go to my website, lilylegal.com, and click on contact us, and you can see my schedule, right? You can see my calendar and pick a date and time that works best for you for us to talk. Okay. If you are watching this on YouTube and Facebook, you can see the scroll on the bottom, right? The sticker on the bottom that has the website and everything. So feel free to go ahead and schedule that. I do offer a free 15-minute strategy session just to get to know each other, see what you need. Sometimes I'm able to answer your questions in 15 minutes. And if there's documents that I need to look at before that, make sure you send it to us ahead of time. When you're scheduling, you see the instructions on how to do that. But yeah, make sure you're sending us the documents ahead of time so I can review it and be prepared to answer your questions. All right. Oh, I see another question. Hi, Charles. I am a U.S. citizen. Filed for my minor children got approved. I-130 for my minor children got approved. Is it necessary to submit the I-864W when enter the U.S. will become a U.S. citizen through INA 320? Yes. Yes. So if you do not need to file an I-864, so an affidavit of support, then you must include that because you have to tell the National Visa Center why you don't need a regular affidavit of support for them. Okay, so you must file the I-864W because you can check off the box that says there will be a U.S. citizen automatically the second they enter the U.S. with their visa, so they don't need an affidavit of support. But they won't know that unless you upload that form. So yes, you have to complete it and upload it for the embassy to know that that is not necessary. If you do not submit it, then their case is not going to be documentarily qualified, and you're just going to be going back and forth with the National Visa Center. So submit it so that they can accept the filing and get them documentarily qualified and get them in line for an interview. All right. Next question. I am asking for my brother. What should you do if your green card expires years ago and you want to renew it? Will it be harder? No, just renew it. So one thing I want people to know is when it comes to green cards, once you're a permanent resident, you are a permanent resident. The card itself is only proof of your permanent residency. So just because the card expires does not change the fact that you are a permanent resident. You just don't have proof of your permanent residency. So typically, if there's no like criminal records that make the person deportable, we have no issue filing a renewal. I have filed renewals like 20 years. Someone that has not renewed it for 20 years. We have filed a renewal and it was approved. They just have to go and do a biometrics, right? So he may be asked to go in to do a biometrics just so they can get an updated picture, fingerprints, all of that. But they will still approve it because he's still a permanent resident, okay? So like I said, unless there's any criminal history or anything like that, that's typically when we would like look at the whole history to see if the person would still qualify or if they can, trigger some deportation proceedings because of the criminal history. But typically, no criminal history, you can renew because he's still a permanent resident. Just let him know that. He is still a permanent resident. He just doesn't have proof of it. So he should file for the renewal so that he can get proof of it. If it takes, right now we're seeing renewals take a few months. So especially if there's fingerprints involved, it may take like a few months to get it, but they've been quick, the renewals as well. But if he needs to travel, after he files for the renewal, he can schedule an ADIT appointment with USCIS so that they can stamp his passport or give him a card that will serve as his green card. Or for example, if he needs to renew his license and doesn't have that to show, if he is applying for a new job and needs proof of his permanent residency, once he files the renewal, he can make an ADIT appointment with USCIS, and then with that appointment, get proof of his permanent residency. So there's multiple reasons to do that. However, he may get the card renewal done before he would even need the ADIT appointment. So really important to keep that in mind as well. You can get temporary proof of your status if you file the renewal. All right. And then that just leads me to the natural next question that people usually ask is, if I want to apply for citizenship instead of a renewal, do I have to renew my card in order to apply for citizenship? Typically, no, because again, you are a permanent resident. The card is proof that you were a permanent resident. So no, you don't have to renew in order to file for citizenship. However, if you need proof, right? If you need proof of your green card while you're waiting for your citizenship interview, you may want to get an ADIT appointment as well. All right. And Leona, you are so welcome. Thank you for asking. Anyone else has questions, please feel free to put them in the comments. I am more than happy to answer more questions if there is any. And let me just make sure I don't have anything else in my notes that I wanted to cover. Okay, so yeah, that's everything I wanted to cover today. I'm just going to do a quick roundup. One, approved I-130 does not mean you have a status. Until your green card is approved, you do not have an actual status, unless of course like you have another status already, or like if you have TPS, you will still have TPS. But if you're just relying on the I-130 to be your proof of status, it does not give you status. If you have a pending I-130, a pending green card application, you also do not have status. However, a pending green card application, if you have a receipt notice on you, could help if you could, right? Remember, it doesn't give you status. However, it could help if you are stopped by ICE. I-130 interviews are being done for cases, even if you're not also applying for a green card with your I-130. In certain situations, they will go ahead and schedule that interview, especially if the person is in removal proceedings. The beneficiary is in removal proceedings. And if the I-130, if the person is in the US, the beneficiary is in the US, and they do not qualify for adjustment of status, if they are deportable, they can be issued a notice to appear even while the I-130 is pending. And then finally, they are handing out notice to appear for cases that are denied and outside of the 30-day appeal motion to reconsider window. So once you're outside of that window and you do not file anything with USCIS about your case, they typically are now at the service center level issuing notice to appear. So know that before you file. I'm not saying it to scare you, just saying it is a possibility, but you can plan for it. So make sure you are talking to your lawyer, knowing what's going on so that you are prepared for anything in this immigration world that we're in right now. But yeah, thank you guys so much for joining me. As always, ask me questions in the comments. If you think of a question that you weren't able to ask me live, jump in the comments, ask me the question. And then if you're watching this on the replay, ask me questions as well. Thank you so much for joining me, and I will see you next week. Yes, I will be here. So thank you all so much, and have a great rest of your day.